Okay. All right. Great. Well, we're just going to go ahead and get started. This is an orientation for new customers. It's also a visit for existing customers and people who've been with us a while. A lot of customers will call, say, I need a refresher. So this is perfect. It's also a perfect opportunity when you have new employees come in that you want to have help you with your pre-liens. So anyways, a little bit about me. My name is Bridget Nielsen. I am the operations manager here at Titan Lien Services. And Paula Mosier, who you just met, is the office manager. And she is everyone's favorite. So if you haven't talked to her, that's why she's not your favorite. You haven't talked to her yet. So anyways, we have found that by you taking this initiative and educating yourself, that and your team, educating yourself and your team about lien rights, and then actually taking the action to put into place really good policies and procedures, that you will be in a much better position if you are faced ever with a customer who is not going to pay. So our format will be me going over what I believe to be the most important information needed. There's a whole lot more. We could dig deeper, but that's not the purpose of this. This is just supposed to be a high overview of that. And you may have questions, and just go ahead and put those in the chat, like I mentioned, but we will have a Q&A in a breakout session afterwards. I will be focusing on Arizona, simply because that is where most of our customers are doing their projects. If you do work in another state, if you could please put that in the chat, and then Paula will let me know, and I will see if I can provide some insight so that I can touch on that state as well. Different states do have different rules. Okay, let's go ahead to the next screen. So these are the most common mistakes that our customers make. The first mistake is when they sign up with us and I have a chance to talk with them. Some of them will say, oh, I know exactly what to do. I know how to protect my lien rights. That tends to be a red flag for me. I think I've only talked to one customer who did really know how to protect their lien rights. Most everybody believes they know, but it doesn't help to just make sure. So thank you so much for taking the time to be here with us. All right. So the second biggest mistake is actually not sending the required preliminary notices. You'd be amazed how many customers call us when they're in a jam, when they've been off the job for a month and they're not getting paid and they think they can just lien the property. Another mistake is people assume that every state has the same requirements. I have people from California doing jobs in Arizona, and they might be the prime contractor and they want to file a lien on an Arizona job they were working on. And they're licensed in the state and everything. But I say, I'm sorry, you don't have any lien rights. Yeah, I do. I said, no, you didn't do a preliminary notice. And they'll say, well, I don't have to. I'm the general contractor. I'm the prime. Nope. In Arizona, you do. California, you don't have to, but Arizona, you do. Another mistake that a lot of customers are making are signing the wrong waivers. I'm hoping to have another webinar specific to waivers, and we'll keep you posted on that. Do check your emails when you see emails come from Titan Lien Services. We really don't send that many promotional emails. So okay, next is a preliminary notice. A lot of people call us and say, hey, I sent a lien on this job. They want to get some more information. A preliminary notice or construction notice is not a lien. So we do often use the term pre-lien, and people will think that that's, a lien. But when you call, terminology is really important. We're looking in a completely different place and looking and panicking because we don't see a lien for you for that project. So anyways, do keep in mind a preliminary notice, construction notice, a prelim, a pre-lien, notice to file a lien claim, notice to contractor, notice to owner. Those are all different names for a preliminary notice, which is sent at the beginning of the job, hence the name preliminary. So it means kind of at the beginning, right? Pre. All right. So don't let those terminology scare you. That those all right there on this page just kind of mean the same thing. All right, I'm going to go over some pre-lien requirements to just, you don't need to take notes here. I'm going to run through it very, very quickly just to prove a point, okay? But this is my point, is that Preliminary notice requirements are very specific, as well as lien requirements and foreclosure and things like that. So I'm going to just touch on 3 different states to show you the difference in different states. Okay, first, Arizona. Arizona, you have to send a 20-day preliminary notice at the beginning of your job in order to protect all of your lien rights. You can send it late, but it only is retroactive back 20 days. So if you've been off the job for 30 days and you send the pre-lien, you have no lien rights because you were still not doing work in 20 days back from then. Okay. You have to record your lien within 120 days from project completion, or 60 days if you were sent a notice of completion. And then you must enforce your lien with legal action within 6 months. Oregon, pre-lien is required to be sent within the first 8 days of the job starting, but only for subcontractors and suppliers, and only on residential jobs. And it is encouraged on commercial jobs. You have to have your lien recorded within 75 days from your last day on the job, which is different than Arizona, which is from project completion, which could mean your last day as well. All right. You must enforce the lien within 120 days with legal counsel. Next, Utah. A pre-lien is required to be filled out online with the Utah Construction Registry within the first 20 days of the job starting. Now, unlike Arizona, where you can send it late and it's retroactive 20 days, whereas in Utah, you are actually penalized. Let's say we go on an online registry and we put your pre-lien in the Utah Construction Registry on day 21 of your job. You are penalized 5 days. So your lien rights don't even start until the 26th day of your job. All right. Your lien must be recorded with 180 days of last furnishing labor, and you have 180 days to enforce a lien. Okay. So you don't have to remember all of that. I am going to give you some tips on when I'm going to go back to that, actually give you tips where you don't have to remember this. Okay. This one you can write down. Okay. You want to send a preliminary notice, whether it's in a state that requires it or doesn't require it, when you start the job or when you have a signed contract. You can decide what is best for your processes, but I suggest sending a preliminary notice when you have a signed contract. Now, let's say you're doing job in Arizona or Oregon, and you don't remember that, oh, I'm a subcontractor, but it's not a residential job, so I don't have to send a preliminary notice. Preliminary notices are so inexpensive that it is, in my opinion, that you just send one on every job. I've talked to so many attorneys. I go to trainings every year with these attorneys. I talk to attorneys that, it's like the Oregon attorney that dealt with Oregon and Washington. I talked to him about preliminary notices when they're not required. He's like, oh, I'd send them. I'd send them on commercial jobs. I'd send them when I'm the general contractor. I would send them. I have not spoken to an attorney who has said when it's not required, I don't send them. I don't recommend people send them. So when you have a signed contract, send a notice. Okay. If you are not getting paid on that job and you sent the notice, as soon as your client is in breach of contract per your agreement, like let's say you have a net 30-day agreement, next 60-day agreement, and they're not paying you, talk to them and be proactive and send maybe a letter of intent to lien or an actual lien, file a lien, and just don't make a big deal about it. Just like, hey, it's okay. We got to protect our lien rights. So we need to do that. You'll never miss a deadline. We have customers often missing deadlines. First of all, they didn't send a pre-lien and often they're too late. They've been off the job 6 months and now they decide to file a lien. It's too late. You're past your cutoff per the statutes. Okay. And then next, once a lien is filed and client may not, just by filing a lien doesn't guarantee you're going to get paid, but it's a really good and effective and inexpensive tool. Let's say you're not getting paid. The lien didn't do you any good, or so you think, right? That's when you want to talk to legal counsel and enforce it. I don't know. I haven't spoken to an attorney that doesn't love when their clients have a lien on it before they get involved. It really helps. All right. When to send the notice. I mentioned this before, but I recommend right as soon as you have a contract. Now, the best practice is to include all parties. Now it's who to send the notice. Best practices include all parties affiliated with the project, including lenders. This is often not public record. We help you search public record for that project. It is really important to get job sheets from your customer or from the prime contractor. A lot of these larger prime contractors have job sheets. They will have lenders on it. They might have payment and performance bond information, but you want to include all parties. I'm going to give you an example of maybe TI work that you're doing at a strip mall or something, like a store's going in. I would notify the owner of the land. We can go find out who owns that property. The tenant that you're doing the work for, or who's going to be benefiting from it, and maybe also the property management company. Now, the only party that we're going to know is that of public record, and that is going to be the owner of the land, the actual dirt owner, okay, of the real property. So, but you also want to do your research and try to get as much information as you can, okay? A lot of people will call us and say, hey, I need to cancel my pre-lien. That's not a thing. A preliminary notice is mailed, just regular mailed. I mean, well, we do track it. Some of them we track, and others are sent what's called certificate of mailing. But it is not a document that is recorded anywhere except maybe Utah, because it's on the registry and anyone can see it. But anywhere else, it's mailed. I can't pull it back. Okay. Now, my question is, why? Why are you asking me this question? Because I'm done with the job. Oh, okay. Well, then just fill out a waiver if your customer's asking for it. But if your customer's not asking for a waiver and it's done, there's really is nothing you need to do. Some people might want to cancel because they think they made a bunch of mistakes. Well, the answer is we just amend the pre-lien. Okay. They might say, well, my customer got really mad and I just need to make it go away. Well, then maybe I can help you in explaining that it's not a recorded document, help educate you so that you can educate your customers. And then let's just say I might indicate to you, well, I think maybe you need some legal advice. Those are some conversations that have come up when customers call us regarding canceling a preliminary notice. We want to know why, because that's really not possible to do that. Now, where it is possible, let's say you just recently requested a preliminary notice and we haven't mailed it yet. That we can cancel. Okay. But I do recommend you call us to try to get us, because some of these jobs we're pretty fast at. If we have all the information we need, we are just trying to get these out as soon as possible. Okay. All right. I wanted to talk to you a little bit about amending preliminary notices. The number one thing, and this is specific to Arizona, okay, this is no other state but Arizona, and it is a confusing language in the statute. So when you have a project for $100,000, you already have lien rights for $130,000. So you do not need to amend your pre-lien to increase your contract amount if that increase or that change order is less than 30% of what your original pre-lien was. Okay. So when you do want to amend your pre-lien is when your change orders go over 30% of your contract amount. Let's say you're on a $100,000 job and you've got change orders now equaling up to 31%. Do your pre-lien and do your pre-lien for increase your contract amount to $131,000. Now, the next time you do a pre-lien would be when it exceeds 30% over the $131,000. You don't need to amend every time. Now, that being said, I do have customers who want to amend it every time because they don't have the time or the bandwidth, because they're suppliers. There's always more material going out the door. They don't have the bandwidth to sit there and calculate, oh, what did I do my pre-lien for? Oh, is this 30% over? Just every time there's something, they just add it because our amendments are $15. They're very cheap. We have kept the price that for years because we want to incentivize you guys to amend your pre-liens. Okay, another reason to amend a pre-lien is, let's say there's an additional party that we identified, that you identified later. Maybe you told us that the general contractor was ABC company, and then you find out, oh, the prime contractor is actually XYZ company. So we'll just amend your pre-lien to reflect that. As soon as you find it out, that's when you want to do it, okay? Let me just go back to this increase your job contract. You want to do this within 20 days of the contract, of the change order, okay? Otherwise, you could lose lien rights. I had a client, liened it. They realized liened a job for, I don't know, $3 million. And come to find out, they didn't do their amended pre-lien in time. So they only had lien rights. We had to amend their lien. They only had lien rights for a third of that, $1 million. Still a lot, but they didn't have lien rights for the other two. So that's a big thing. You want to amend immediately when you know there's a change. Okay. Let's say you find out down the road, oh, there was a performance and payment bond on that. We need to notify the surety or the insurance company. So let's add them to it. Okay. Let's say there was, you found an incorrect address on there, or your client moved offices and they may not have gotten the pre-lien. So we just correct an address. So those are some ways to do that. You always want to amend your pre-lien, if at all possible, rather than creating a new one. The reason why is it goes back to the first date that you sent your pre-lien. You sent your pre-lien on January 20th, your lien right, or 21st, your lien rights began on January 1st. Now, let's say you have change orders back in May and you do a new pre-lien. Someone could say that your lien rights only go back to 20 days back from that May. But if you amend your pre-lien that you sent in January, your lien rights still go all the way back to January 1st. Okay, it's better to amend your pre-lien. All right, a letter of intent, also what we refer to as an LOI. Some people refer to them as an NOI, a notice of intent to lien. But in Arizona, LOIs are not a statutory document. They're not required. Colorado, they are required. But it is a really good tool. They're $75, and it is something that comes from us, from a lien company, that kind of lets your client know, I'm really serious. I have a lien company over here, and if you don't pay me by a certain date, I'm going to lien your property. Now, we don't have to do that. You can do that on your own. But some people just want it to be on our letterhead to say Titan Lien Services, but it's not required. It is really effective in helping you to get payments. As soon as someone warns someone else of an upcoming lien, they kind of scramble sometimes, and sometimes they don't care. We don't know. But one time I would suggest not using a letter of intent to lien is if you're up against a lien time frame. We don't want to take the time to do that. We need to work on your lien before you lose lien rights. All right. An Arizona mechanics lien, if you did not do a preliminary notice, we cannot prepare a lien for you. It's that simple. Now, if you just started the job and it was last week and it was a 2-day job, you still have time to send your pre-lien. And then we could send your pre-lien, and then we could do your lien because you're still within the time frame. Okay. But liens must be recorded within 120 days from project completion, or 60 days from the recording date of the notice of completion. A notice of completion, I'm just going to mention really quick, it's actually a recorded document. Not many people do them. It doesn't happen very often. But if you ever got a recorded document from a county and it's recorded and it says notice of completion, look at that job, make sure you've been paid on that job. And if you have not been paid on that job, file a lien immediately, because your lien time frame just got cut in half. Okay. Pre-lien must be sent within the 20th day. Lien must be recorded. Okay, and you have 6 months from the lien recording date to begin legal action. This is all specific to Arizona. We've gone through those other items. Let's see what else there is. Okay. Performance and payment bond. A lot of people are not sure of what this is. It's like an insurance policy, but it's not. It's a bond, but it kind of acts like an insurance policy. So, for instance, let me just share with you, there are private jobs and there are public jobs. A public job means the project is on land owned by a government. It does not mean it's a public place like McDonald's where you walk in. In lien terminology, a public job is a government job. City, county, state, town. You cannot lien public property. You can't take the government's land away from them. Okay. So what you have as your protection is a bond claim, but there must be a performance bond and a payment bond. They come together, just so you know, they are two different documents, but I've never seen one without the other. So the one we're really concerned about is the payment bond. They always have the same number. So if I were you and I was ever working on a project that was owned by a city, county, working at the county courthouse, okay, you know that is a government job. I would always request and require that I get a copy of the payment performance bond. If you are told there is no payment performance bond, you will have no recourse. You will not be able to file, no, I shouldn't say no recourse, period. You will not have the ability to file a lien, nor will you be able to file a bond claim. Okay. You would just, your only recourse would be some type of legal action. Maybe with the ROC, you can file a complaint against your customer, if their customer is a contractor, or breach of contract, and you can do that with legal counsel. Okay, but if it is a public job, I recommend you always getting a payment performance bond. If you are told there is no performance bond, then it becomes a business decision as to whether or not you move forward with that job. Okay. All right. In Arizona, on public jobs, it is still required to send a preliminary notice. A copy must be sent to all the same parties, as well as a copy being sent to the surety. And then if there is a bond number that's already been assigned, then we add that. If the bond number comes later, we can amend the pre-lien and add that. Okay. Then a bond claim must be filed within 90 days of the claimant's last day on the job or last delivery date. So it's different than the lien timeframes to file a lien. Lien releases. I have customers doing lien releases when they have not been paid in full. You are doing that on your own. That's your own business decision. We can't give legal advice. We're not telling you what to do, but I just will tell you this. We recommend that you do a lien release. If you filed a lien on the project and you are actually releasing that lien, we recommend that you are paid in full. Or let's say you negotiated a rate. That's a new amount. That's fine. You've been paid in full. That's when you should release the lien. It is a business decision. I do have customers release liens often when they haven't been paid. That's their decision. But I will tell you that if you have released the lien and you need to lien it again, I'm going to probably refer you to legal counsel to move forward with your next steps. Okay. We do lien releases. They are $75, or our liens are $350. Our LOIs are $75. I think I mentioned that. And our lien releases are $75 plus the recording fees. There is a recording fee and a mailing fee. If you release the lien prior to payment and the funds are not deposited into your account, we're going to request that you talk to an attorney if you don't get paid. And I mentioned already that it's best practice to release the lien after your funds are in your account. Here's a scenario that recently came up. I had a client, they liened a job last year. The next month, they received the payment, they released the lien, and then they continued to work on the job. If it were me, I would do a new pre-lien moving forward. Because now I had to refer them to legal counsel to determine if they still have lien rights because they didn't do a new pre-lien. Can they still have lien on that first pre-lien? Anyways, so once it gets a little bit gray, that's when we have you reach out to legal counsel. All right. Few things regarding commercial jobs and residential jobs. Commercial jobs, the real property owner must contract for the improvements to be made in order for you to have lien rights on the real property, meaning the dirt. Let's say it's a tenant. If a tenant is requesting work in their place of business, you may only have lien rights on the leasehold interest and those improvements and not on the real property itself. So if you are ever doing tenant improvements, I recommend you trying to get as much information you can to the party that you're working for. If you're working for the tenant, just say, hey, in your lease, does the real property owner give you the leeway to do this? And they might say, no, they just told me I'm on my own for that. That's really good information to have. Document it. And then you could you can still send a lien, but it's not attached to the real property. It's only a lien on the lease, the value of the lease. It's not as powerful as a lien on the real property. Okay. But if they say, yeah, it's part of our lease agreement, they know what tenant improvements I need, they've agreed to that, and they're giving me leeway to do that. Document that. That helps us. Then we would lien the real property. All right, next on residential jobs. This is specific to Arizona as well. If the property is considered owner occupied, you only have lien rights if you were hired and have a contract directly with the owner. Now, I am going to explain to you in Arizona terms of what owner occupied means. It means the Smiths own a piece of land and they intend to build a house there one day. That is considered owner occupied. Let's say the Smiths own a house and they are renovating it and they intend to live there. Or the Smiths are building a new house. They don't live there now, but they intend to live there. That's an owner-occupied residence, okay? Whether there's people there or not. Now, let's say the Smiths own a house and they're going to build a house, but when we look up who the owner is an LLC. Well, this whole rule goes away. It's not an owner-occupied residence because it's owned by a company. You would have lien rights. Whether if you were hired by a general contractor and the owner of the property is a company or an LLC or, a corporation of some sort, you have lien rights. You don't need to have a contract directly with the owner. Now, if you are a subcontractor and you are contracted with a GC on an owner-occupied project, you have no lien rights at all. I suggest to my customers a couple things you can do is, if it were me and it was a really good opportunity, it was a really good job, and maybe the GC I've worked with a lot, I really trust them, that's a good business decision, okay? But if it's a new GC, I haven't worked with them before, I would still, even if I have worked with them, I would still ask them to give you a copy of their preliminary notice. Make sure they're doing a preliminary notice. You'd be amazed how many general contractors do not do preliminary notices, and educate them about it, because the GC's preliminary notice is going to protect you, because the GC's preliminary notice has the full contract amount includes everything that you're supposed to be doing, that other subs are doing. And then if the owner doesn't pay, the GC has the right to file a lien, okay, and get paid. Now, if the owner pays the GC everything and it's the GC that doesn't pay you and you're a sub, you can't lien the property. That's when you take legal action upon, based breach of contract, or you go to the ROC, maybe file a claim there. So just be aware, if you are working on an owner-occupied residential and you are a subcontractor, make sure the GC has a pre-lien, or see if you can talk to the GC and see if you can just have a direct contract with the owner. But that's the only way around it that I can see. All right. We're going to talk a little bit about waivers and releases. A waiver and release is different than a lien release. Okay. Basically, a waiver is what you use when you've sent a preliminary notice on a job. because everybody gets it. The owner gets it. Everyone gets it. So people are keeping track of these preliminary notices. And the owner might require the general contractor, okay, I want everything from October. I want to make sure everyone's been paid for October because I've paid you for October. So you got to prove to me that everyone's been paid. So that's when the GC might go to you and say, hey, can you send me a waiver monthly? They might want that monthly. Okay. So if they don't ask for one, I mean, you don't have to do them on every job. Oftentimes I have this orientation and people think they have to do these waivers for every pre-lien that they do. You do not. You just really want to do it when it's requested. Now, the types of waivers, people make a lot of mistakes here and can lose lien rights. Make sure you choose the correct one. Unconditional, that word unconditional means money is in your account. It does not mean you were handed a check. It means the check was deposited and cleared. Those are the only times you would give what's called an unconditional waiver. Okay. This unconditional waiver on progress payment is if you're still on the job and they just made a payment for October. You would put, I've been paid through October 31st, this amount. That's it. If you are done with the job and you've been paid in full, you don't even put a dollar amount on this. There's no space for a dollar amount. You have unconditional on final payment. You've been paid in full for the job. It's over, completely over. Okay. If they call you back to do more work, do a new pre-lien because you just waived all of your lien rights on a done job. So you got to start all over with a new pre-lien. This one, you don't have to start over with a new pre-lien. The project's ongoing. Okay. Customer is going to pay you for October. They have not paid you yet, but they want a waiver. You would do a conditional waiver on progress payment. October, you owe me $10,000 for October this goes through October 31st. And once I am paid that $10,000, I am stating that I have been paid in full up to October 31st. Okay. Conditional on payment. You have a final payment due of $10,000. You put $10,000. And once that is paid, you are indicating that you waive and release all of your lien rights once you receive that payment. Okay. Don't go quickly on this. You can always call us if you have questions on waivers. All right, I'm going to give you a few tips and tricks. Before we get started on the tips and tricks and suggestions, are there any questions in the chat, Paula?
No.
Okay, awesome. All right, first thing I want to talk about is job sheets. So this right here on the left side is an example of a job sheet. Some people call them a pre-lien job sheet. A lot of general contractors put these together so that everyone has accurate information about the project. Who owns the project? Who owns the land? Who is the tenant in there? Who is the lender on this project? And sometimes they put architects and engineers, okay? You don't normally have to include them on the pre-lien unless you're working directly for them. Then they would definitely need to be on the pre-lien, the architects and the engineers. So this has all your information. But don't just assume this is right. This was created by a person who makes mistakes. There could be a typo. Please make sure that you go to this address and you confirm, yep, that is the project. There is not a typo in it. That is accurate. Okay. The rest of it you may not know. That's fine, but you do know where the project is. Okay. A job sheet could have the construction manager on there, could have the tenant, the property management company, lender, could have lender on here like this. It could have bond information. This is all the information you want to put into your preliminary notice, and you want to notice all these people. Okay. And we're noticing this project address. We're referencing this job address. And if for some reason I go to that job address and I see another company, maybe called Apex Heart and Vascular with a longer name or something, like it's like a part of that, or I'm sorry, right here, Heart One Deer Valley LLC, and I see another owner as a recorded owner that maybe is called something similar to that, I'm just going to add them as a second owner because I want to get the recorded owner of record at the time we do your preliminary notice. Now, that being said, the counties aren't always right. So, but it's better to over notice parties than to under notice and not get it to the right people. All right. Sometimes there's not an address. Okay. And I want to give you an example of how you describe where the job is. You don't have to put an address, but you do have to help us identify what property you're looking at because we look at this right here. And if you say the southeast corner, that's what SEC means, of North Desert Peak Parkway, here's North Desert Peak Parkway, and East Hillstone Way, which is right here, southeast, okay, then I know it's this. And I click on this and it's a new development going in. There's no address. I know exactly what piece of property and I am going to find an owner. 99% of the time, I find owners. Okay, there are a few times where it's pending and I don't know who the owner is. Then I might reach back out to you and see if you have any insight, see if you got a job sheet. I do recommend if you have a job sheet, look through your contracts because a lot of times you do have a job sheet and upload that. There's an area when you put in a job on our website, on your portal, that you can upload that. That helps us to answer a lot of questions and we can get your preliminary notices out much faster. Okay. So this is what you would put for the address, or you could just put east of North Desert Peak Parkway and Hillstone Way because it's this whole section east. All right. That's one example. Let me give you another example. Be specific. Know where your materials are going. Okay. Let's say you just give me the address of 14545 West Grand Avenue. Well, this whole area, or maybe this whole thing is, I don't think you're doing this whole project. Like, tell me it's going in this corner suite number or something, or here, or we need to know where it's going. So I do recommend whoever is putting in your preliminary notices that they should know where the project is located, not necessarily the delivery date of your delivery location of your materials, because that could be misleading. Okay. Let me go back to this really quick. I'll give you an example of a delivery address. A lot of times when there's a big project, they might have a staging area, maybe where the GC has a trailer, where a lot of equipment is stored, and they're just leasing that land temporarily to just be a staging area. And you have a delivery address of that piece of property, but it's the adjacent property that's being built and being improved. Do not put the delivery address of on your pre-lien because you are filing a preliminary notice on a piece of land that there's no improvement happening there and you may not have any lien rights. So always know what piece of property is being improved. I want to share another example. I had a client who does barricades in streets when there's a project. There was a big school, a brand new elementary school being built or high school being built. I think it was down in Queen Creek. And the city required that they have barricades to help with traffic. And the barricades were a block away. They put their job address as the corner of that street where their barricades were. That's the property we pre-liened, public land on the corner of this street and this street. But they didn't have lien rights. I mean, they ended up not liening it, but they didn't need to lien it. But they don't have lien rights because we did not notice the school district. We did not get bond information. We didn't know what project this was about. So always know and identify, why are you doing this? What is being improved? Okay. So lien rights are always attached to permanent improvement to property. All right. So we're going to go over into our breakout room pretty soon. But I have two questions that I really, really like a poll on. If you could get your phone out and just use your scan the QR code and just answer two questions. It really will just take a couple minutes. Actually, it will take a couple seconds. So it's just two questions. One is, Was this helpful? We really want good feedback on that. And second is, did you receive the information you need to actually make changes to your processes and policies and how you do business and how you protect yourself? Those are the two